Good morning, everybody, and welcome to this licensing committee held by remote video link on Friday, the 9th of April at a few seconds after 10 a.m. So apologies for the late start. I would just like to also welcome to this meeting officers of democratic services and legal services. And I'd like to move to Frank Carroll to conduct a roll call, please, and then if you could provide a meeting explanation immediately following the roll call. Thank you.
Thank you, Sir Chairman. Can you please confirm your attendance, members? Councillor Webster.
Present.
Councillor Laband.
Present.
And Councillor de Bell.
Present.
Thank you. Moving on to the introduction, good morning, everybody. Regulations have been introduced to allow the Council to hold its meetings remotely. To ensure smooth running of such remote meetings, it has been necessary to amend some of the Council procedure rules, and such rules have been amended by the Head of Regulatory Services. Consequently, the following procedures will apply to this meeting. There will be a speaking order for this meeting, and the order has been circulated to all parties prior to the meeting. During the meeting, all participants will be in control of their own microphone. You should set your microphone to mute until such time as the chairman invites you to speak. If you wish to speak, you should indicate by activating the raise hand function found at your participants list. Please be patient. The chairman will know that you've indicated a wish to speak and will get round to all participants. And the chairman has absolute discretion as to the order in which he invites participants to speak. When the chairman indicates you can speak, you must unmute your microphone. Once you've finished speaking, you need to mute yourself again, and please also remember to lower your hand when you have spoken. If you do lose connection to this meeting, try to reconnect using the same calendar link and password which you've already been provided with. On occasions, it may be necessary for the chairman to take advice from officers, and this may cause a slight pause in progression of the meeting. Should the chairman wish to adjourn the meeting at any time, he will advise the meeting that it is adjourned and at what time it shall reconvene. All participants are asked to remain in the Zoom meeting with their microphones muted if this should occur. Once the members have heard the representations from all the parties, the public meeting will end, and the members will retire to discuss the application, and a decision will be made within 5 working days of the meeting, and the letter will be sent to all the participants and any other parties who've made representations that did not attend the meeting. Thank you, Chairman. That concludes the virtual meeting explanation.
Sorry, I've committed the usual sin. Sorry about that. Thank you, Franca. And the next item is to receive apologies for absence, which of course there are none, and then to receive declarations of interest from members in respect of any matter on the agenda. Colleagues, do you have any declarations of interest? No, thank you. To confirm the minutes of the meeting held on the 30th of July 2020, and you asked to use your yes or no button, and as I was the only one present at that meeting, I will raise my hand in agreement of those minutes, which I have now done. And those minutes are therefore accepted. And that moves us on to the application of a new premises license. And I would like to invite the Senior Licensing Officer, John Bryant, to introduce this item, please.
Thank you, Chairman. Members, the matter before the panel today is application for a new premises licence. The purpose of the report is to provide information in order that the licensing committee can determine this application. And in summary, the application pursuant to section 17 of the Licensing Act 2003 has been made by ACSC Services Limited, which is a trading subsidiary of Ansty Sports and Social Club, for the grant of a premises licence for the newly constructed Ansty Village Centre at the recreation ground Deeks Lane, Ansty. 4 residents, interested parties have submitted representations objecting to the application on the grounds of public nuisance, and one further one on public safety, which I will detail during the report. The committee is asked to determine the application in accordance with the Licensing Act 2003, the Mid Sussex District Council licensing policy, and the Home Office guidance issued under section 182 of the Licensing Act 2003, whilst having due regard to the applicant's submissions and relevant representations. The background to this matter is outlined in the report. Ansty Sports and Social Club has operated on its existing site as a members club since before the Second World War, and it has provided an umbrella for various sporting clubs and sections over many years. The club has operated under its current licensing arrangements under the authority of a club premises certificate for well over 30 years, without any recorded complaints to the department or intervention from the police or other authority that the licensing team are aware of. The club is moving to a new building and the existing one will be demolished, and therefore the club is seeking a new licence. A premises licence has been applied for rather than the club premises certificate, as it offers greater flexibility in the operation of the facility, and it also places the club under a clear set of responsibilities. In addition to the application, the club has provided a lengthy explanation of the proposed operation of premises, which is appended to this report after the application. The application was correctly advertised at the site between the 17th of February and the 16th of March, and also in the Mid Sussex Times on the 26th of February. At Section 8, you'll see the applicant seeks the following licensable activities and timings, which is the supply of alcohol for on premises only, every day between midday and 2300 hours. In addition, they request to be able to supply alcohol up to midnight closing on up to 12 days of the year, which includes Christmas Eve, New Year's Eve. And these events, these occasions will be for special events such as birthday parties, club awards nights, etc. The opening hours, daily opening hours for the premises will be every day between 0900 and 2300 hours, and the non-standard opening hours as requested will apply on the 12 days a year. There have been 4 representations received from nearby residents who are interested parties to this application, and I have attached the details, full details of these representations and appended to the report, and they will be referred to by the submissions by the interested parties. The committee should be aware that when reading the representations, that some of the information contained therein is irrelevant for the purposes of the Licensing Act 2003. These are the comments relating to planning, although there is one aspect of planning which I will touch on when I go through the report, which may be relevant. Car parking, timings, odour from the premises, people driving to location, etc. The main points raised in the representations that are relevant relate to the licensing objective of public nuisance and refer to the timings in respect of the use of the outside area and noise from the use of the area and the club. The committee must focus on these parts only and disregard irrelevant matters when determining the matter. If the committee decides to grant a licence, I request a number of conditions which have been offered in the operating schedule to be attached. They relate to the use of CCTV, staff training, closure of doors and windows, and the use of outside areas. Full details are attached in the appendices, and obviously the committee may feel that other conditions may be appropriate given the circumstances after they've heard representations from all parties. At the time of writing the report, the premises are still in the stages of construction. and therefore it's was only possible to provide pictures of the exterior, but these show the location of the current licensed premises, which is due to be demolished. And just in reference to that, the photographs, be the 5th and 6th photograph within your pack, shows in the background the current social club for your reference, and also the position of the new social club. I'll move on to the representations. 4 representations have been received in respect to the application, which I've summarised. Mr. Sparham, he's expressed concerns in respect of the application for up to 12 events within the non-standard timings. The comments which have made in regard to additional TENS applications is irrelevant to this application. He has concerns regarding the use of the outside space, the potential for noise nuisance after 2100 hours, and his full representations are attached to the report for the committee's information. Emma and Jonathan Sparham have expressed the same representations regarding the use of the outside area and potential for public nuisance, and again their full representations are attached to the report, and the committee will be able to speak to all the interested parties for them to fully outline their concerns in detail. Joanna Stedman has outlined representations in respect to public nuisance surrounding the use of the outside space and additional hours that have been requested. She also draws attention in her submission to the planning consent, which this morning I have arranged to be emailed through to all the members and interested parties. And that is in respect of the use of the balcony. The members will see that the relevant part is within the assessment, which comments on the building control requirements for the additional means of escape from the first floor rooms onto the balcony, and the depth of the balcony being increased to facilitate it, to ensure that there's adequate pass space between the exit doors and staircase when people are using the balcony. And Karen Sedgwick-Smith has also outlined representations in respect of public nuisance surrounding the use of the outside space. As I stated, the full representations from all the interested parties are appended to the report for the members' information. The policy context is that the committee must determine the application in accordance with the Licensing Act 2003. The Mid Sussex District Council licensing policy and the Home Office guidance issued under section 182 of the Licensing Act, whilst having due regard to the applicant's submissions and the relevant representations. For the benefit of the members, I have set out section 18 of the Licensing Act, which details with the determination of the application. I don't propose to read out the actual legislation as it's there for the members. Relevant representations. The Licensing Act 2003 requires representations to address the 4 licensing objectives, which are the prevention of crime and disorder, the promotion of public safety, the prevention of public nuisance, and the prevention of harm to children and young persons. A representation is a relevant representation if it is about the likely effect of the grant of the licence on the promotion of the licensing objectives. The objector must establish that such a consequence is a likely effect of the grant, i.e. more probable than not. In order to lawfully provide licensable activities that applied for, the applicant, they must be conducted under the authority of a premises licence. And the final decision made by the committee in this matter is subject of an appeal, or could be subject of appeal to the Magistrates' Court by any party to the proceedings. So attached to the report are the background papers, which are Appendix 1, which is the application form and plan of the premises. Appendix 2, which are the further submissions and explanations submitted by the Sports and Social Club. Appendix 3 are some photos of the location. We also have the plan of the premises. I also have provided a block plan. Unfortunately, because it's a block plan, it doesn't show the current building which is under construction, but it does show the current social club premises and should give the members some context as to where both buildings are in relation to each other when viewed in connection with the photographs. The representations, we have the representation from Mr. Peter Sparham, the representation from Emma and Jonathan Sparham, the representation from Joanna Stedman, and the representation from Karen Sedgwick-Smith. The other documents attached are the schedule of proposed conditions, which I mentioned. Unless I can help the committee further, that's the report regarding this application.
Thank you, Mr. Bryan. I see there's a message in the chat from Peter Sparham to say that he's trying to access the meeting but does not have access to sound. Could somebody from Democratic Services please assist him if he's still having problems?
I'm now with you, sir. Thank you.
Good, thank you. Right, members, do you have any questions which you would like to ask in terms of the report that you've just heard from Mr. Bryant? And if you do, could you please raise your electronic hand? Councillor Laban.
Thank you, Chairman. It's really just a clarification. Is in terms of the report, I'm reasonably happy with the clarity of the report. I do wish to actually ask a question about collections, but I want to make certain I do that at the appropriate moment. And so the question is this the appropriate moment?
To ask a question about?
Refuse collections.
Go ahead, ask the question, please.
Thank you. I note in the report that the applicant has stated that commercial deliveries, collections and storage disturbance, including beer deliveries, blah, 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 will be restricted to working hours between 8 in the morning and 1800 hours at night, Monday to Friday. Whilst that's the intention here for the application, I'd like to know if that's actually detailed in the contracts with the suppliers and will be on their manifest for beer deliveries and also for the collections from the waste disposal companies. Please, thank you.
Mr. Bryan.
I think that is probably a question that Mr. Thorne will be able to address with far more clarity than myself.
Thank you.
Sorry, it's John Thorpe, not John Thorne, but that's not the first time that's happened. So we have not yet. It is the intention. It isn't in specific contracts at the moment, so we haven't actually done that, but we intend to, and certainly I'm confident that we can do certainly with regard to beer deliveries. With regard to refuse collections, I'm less clear, but I would need to take that away.
Thank you. Any further questions, Councillor Laban, seeing as we are with you?
Thank you, Chair. Is it possible or is it necessary for the licensing officer to provide guidance in terms of the timings on those collections, just for the absence of doubt, please?
Mr. Bryant, do you have anything to add to that, please?
This isn't something we would particularly advise on. That would come from the Environmental Protection Team. However, once the application and representations have been considered by the panel, it's a condition that the panel could, if they wish, ask to be attached to the licence if granted.
Okay. Thank you. Councillor Laban, anything else? No, thank you. Councillor de Bell, do you have any questions?
I think, no, not at this stage. I think Mr. Bryant has done a very comprehensive report for us and it details all the information. Yes, so thank you.
Good, thank you very much. Mr. Bryan, I have one question, and that is that you mentioned that the issue of TENS applications was irrelevant. For the benefit of those people listening in, could you please explain that a little bit further?
Certainly, Chairman. I'll just get through to the relevant representation. In the representation, it states there that in addition, the premises would be permitted 15 temporary event notices. In a worst case scenario, the premises would be split into different areas. For example, the village hall could be designated and have 15 TENS together with 15 TENS for the club. There appears to be a misunderstanding by the person making that representation, which I believe is Mr. Sparham, with regard to temporary event notice. The premises wouldn't be permitted to have that number of temporary event notices. In addition, there are a number of temporary event notices that would be allowed at the premises, with actually events up to 21 days. So an event can actually take place over several days. So it's slightly misleading with regard to the comments on temporary event notices. Temporary event notices are dealt separately from the actual premises license, and they're subject to separate applications, which are reviewed by the police and the environmental protection team, whether or not they should be granted.
Thank you. And a further question that results from your answer is, have the Sussex Police or any other agency made any comments that need to be discussed, in your opinion?
Now, there's no representations made by the environmental protection team. The police made comments with regard to comments in the application about people being able to take their drink around the perimeter of the cricket ground whilst matches were in place, but that has been resolved to their satisfaction by containing any drink into the actual designated area outside the premises, which is on the plan.
Thank you. And my next question revolves around the issue of CCTV and how that is monitored. And that may actually be a question that we can direct to Mr. Thorpe in a few minutes' time, and he can perhaps answer that. But do you have anything to say about the CCTV, Mr. Bryan?
Members will see that on the proposed conditions, there is the CCTV condition, which, as you see, is quite detailed. It details that the equipment must be of sufficient quality to work in all lighting levels. It must be retained for a minimum of 31 days. It should cover internally and externally all public areas, including the entrance. It should record and display the times and dates, which should be checked regularly to ensure their accuracy. The management will give full and immediate cooperation and technical assistance to the police in the event that any CCTV footage is required. And likewise, that cooperation would extend to the licensing team for any complaints we received. All key staff would be fully trained in the operation of the CCTV and be able to download the footage without delay or difficulty. And any breakdown or system failure would be notified immediately and remedied within the time frame agreed with the police. So the CCTV condition which is proposed is quite strict with regard to its use.
Thank you. Colleagues, do you have any further questions following on from that discussion? Councillor Liband or de Bell? No, Councillor Liband.
Thank you, Chair. Would Mr. Thorpe be able to actually talk us through the bottling out policy, please?
Yes, we'll come to the bottling out policy. I think that's an important point that needs to be discussed. And I'll then go on to invite Mr. Thorpe to address the committee, please.
Thank you.
I'm sorry, you've gone on to mute again.
Sorry, a big pardon. Can you hear me now?
Yep.
Thank you, Chair. I don't want to say too much. The application, we sought to be as detailed as we could be. We were very happy also to have the opportunity to provide further clarification on the 22nd of March in response to the comments made by respondents. And it is in that part of that response which I might just draw out a few points in terms of you took the opportunity to try and set the context around the application, to be clear about how the members club would operate, the history of the operation in terms of we hadn't had any incidents, certainly to my knowledge, and certainly to people who've been around a lot longer than I have, with involving the police or the authorities, which the senior licensing officers was already mentioned. I sought to explain the governance changes. We do not think the members club model that we had with this Ansty Sports and Social Club is really fit for purpose for the moving into the new premises. So we have restructured the governance, so setting up a new charity to deliver the activities that the majority of activities that Sports and Social Club dealt with delivered, but set up the company under that structure to actually manage the bar, and actually do recognise that with a premises licence application that places much greater discipline on the operation of the bar, which we are very happy to accept. The other point was around community engagement. We are acutely aware of the potential impact on neighbours, and we will work with neighbours and work closely to make sure that we operate in a sensitive and a responsive manner. And so I think as we go forward, and subject to the licence being granted, we do want to work closely with neighbours on all sides of the property and in Deeks Lane to make sure that if any potential impact is managed and is dealt with appropriately. On specific points, in terms of the respondents, there were clearly concerned about noise. We felt, and the Alcohol Committee felt, that we dealt with that quite fully in the original application, so we made no specific proposals there, but we did accept that we needed to be more clear on glassware and how we would deal with all of that, and we've sought to strengthen that equally with regard to the outside areas and the patio and the balcony. Sought to be more specific in the response on the 22nd to say how we would indeed deal with that. On bottling out, this is help me here. This is on taking the bottles out to the bottle bins outside the property. Yes, is that right?
Yes.
Yeah. Okay. So this was a point that was drawn to after we'd made the application. Actually, the Ansty Village Hall Trust, who are a partner in the project, sort of drew this to our attention as one of the issues, and so we will not be bottling out until after 8 o'clock, and indeed we'd be happy to even delay that even further in the morning. So we want no bottling out after a period of time in the evening as well, because we'd absolutely recognise that the sound carries. So we'd be happy to restrict that to a particular period during the day, in the morning, and not to carry that out sort of into the early evening either, because we're fully aware that we think we can do it quite effectively within that window, and that's how we would propose to do it.
Good, thank you. Colleagues, do you have any questions? Just to get the ball rolling, you mentioned, Mr. Thorpe, in your presentation to us, which thank you for that presentation. You mentioned the public engagement and what you would plan to do in the future. I noticed that the submissions contain some concerns about the lack of public consultation in the development of the site, and I wonder if you could just explain to us what public consultation you have actually done in terms of your planning application and so on, please.
So the gestation of the planning application has been taken a long time. So there was a public consultation in 2013 at the early stages of the project, which I wasn't really directly involved in, but at the point at which we prepared the first planning application, we had a public consultation there and an exhibition of the plans. I'm going back to 2016. And then on the present design, we had a consultation on that as part of the planning process, and we had a further consultation which was led by the parish council, which was around perhaps linked to its own funding of the project as well. So that took place in the last main consultation was in 2019. That's when that took place. So there have been certainly 3 specific public consultations over the last sort of 5-6 years, mainly linked to the planning applications. I don't have the precise dates to hand, but I could find those.
No, don't worry. Thank you. And with regard to future consultation and the reporting of concerns that residents might have on particular occasions, I note that there is a telephone number to call and so on. Who will be responsible for the immediate answering of those telephone calls, assuming that there may be problems?
Sorry. Yes. So clearly, if there are problems, they need to be responded to immediately. So the current chairman of the social club will be the designated premises supervisor in the immediate term. He's now got his personal license because he will be on site more often than anybody, and so it will be that individual who's in charge will be answering the phone. The plan in the future is to appoint a general manager for the premises. It's quite difficult to launch that recruitment at the moment because of the uncertainty, but ultimately that person will be the DPS, and that person or his or her nominee will be responsible at any particular time who's in charge, and will deal with the request. In terms of wider engagement, there are a number of things that the project has to deal with. In terms of we have to undertake an exercise to extend the car park, and I think part of that we will be consulting with residents and having meetings with them. But also, I think we would want in the early stages of the operation of the new of the bar itself to have regular contact and to ensure that where there are concerns that we're hearing them, and that that residents, both respondents here, but also those in Deeks Lane and in neighbouring properties, understand what we're trying to do. And if we fall out of line with that, or we're finding difficulty in implementing, having particular challenges, that we actually identify those and respond to them promptly.
Thank you. Councillor de Bell.
Thank you so much, Chairman. Now, I may have missed something here, and I've looked all over the report. The activities at the club will be for members and guests only, I take it, Mr. Thorpe, and so it won't be the sort of place that can be rented out for other groups to use, or for other social events to take place there on a fee-only basis. It is basically for members and club events. Is that correct?
So yeah, the premises, the club room, could be rented out during the day, because for any type of club really, but in the same way that and as an adjunct to the village hall, which there is a village hall in the premises, which it is open to the public and will be available for hiring. The club room could be hired out during the day, but during the evenings it will be basically open to members and members of the community. So the membership is basically the members of the sporting section, the people who come onto the site to play sport. There will be a social membership offered for people outside of the area, but also a membership for Anstey residents at a discounted rate, which is what the parish council were quite keen that that we achieved. So those are essentially the membership classes. I think my understanding is that under the premises license we have slightly more flexibility in how we operate, so not stuck by sort of signing in and things like that. But we are thinking very closely about how we administer the membership scheme and making sure that it's not abused and that people aren't consistently bringing guests in that either should be applying for membership or whatever. But we're looking at how we police that, including from time to time, periodic presentation of membership cards should that be necessary. But it's not a massive club, and I think most people will be known to to the people who are actually managing the bar or managing the club room.
Thank you.
Thank you very much indeed for that.
Mr. Bryan, could you please just explain the point around members and the signing in of guests into the premises, and why that is not being proposed here, please?
Certainly, Chairman. Members clubs generally operate under a club premises certificate, which provides far more restrictions on the persons able to enter the premises. There's a membership of the club. Members are permitted to sign in guests. There are restrictions on the time people have to wait to become members. And that model of operating is in essence quite outdated in respect of a lot of social clubs, and it restricts the operation of social clubs in respect of the supply and sale of alcohol to other visitors to the club. Having a premises license, although the Anstey Sports and Social Club will have a membership, and as with a premises license you can restrict who enters the premises, but it gives you far more flexibility on admitting people than the actual club premises certificate.
Thank you. Ms. Carroll, is there anything that you would like to add from a legal point of view?
Just to say that it would be for the club's own constitution to set itself up, but it in order to meet its requirements as a charitable organisation and as a social club, it will need to meet association guidance, etc. in that respect. If the committee is minded to, then you could consider asking if the applicant would consider operating the membership more along the club premises license certificate way, or if you're satisfied by the measures that the club have set out that they would take in the operating schedule and also today, then you could leave it to the club to decide to manage itself. Bear in mind there is always a review of a premises license in the event that there are issues that arise that the licensing authority, police, environmental health, etc. have, and including the residents as well. If things aren't operating the way they should, then the matter can always be brought back before the committee to decide to review the premises license.
Are there any time limits on those sorts of activities or reviews?
No. Whenever the premises license or club premises certificate is in operation, you have anyone can review it at any time.
All right, thank you. Councillor Laban.
Thank you, Chair. For the club, Councillor de Bell touched on external hire, etc. One of the questions I had was relating to when you do have, shall we say, larger gatherings. Is there or should there be a maximum number of people that can fit into the premise, into and onto the premises during a special event. And I note that you also plan to have SIA operatives if you do have late nights after 2300 hours as well, which is good. So that question stands in terms of numbers, please.
Good, thank you. I suspect that that's probably a planning point that has possibly been covered. Mr. Thorpe, do you want to respond to that, please?
Yes, so yeah, it has been covered in terms of planning and indeed planning control have been involved in this. We have actually, although not in the club room, but the village hall has already been adapted in order to allow it to accommodate upwards up to, well, technically 200 people. That's not feasible. I think the village hall think in terms of like 120 people upstairs as well. We think that the sort of capacity of the club rooms, with given the furnishings and everything else, will be, you know, realistically around 100. But I think in terms of from a planning control perspective, that number may be slightly higher. But we think in terms of the operation for any particular event, we think sort of we haven't actually set a precise ceiling on this, but we think around 100 would be sensible. It's 100 square meters in area, but it will be furnished, and so that's what we're thinking at the moment.
All right, thank you.
If I may come back, Chair.
Certainly.
Thank you. Specific, where I was heading was, if there's a wedding and we've got 250 guests booked, how would that align itself in terms of preventing public nuisance? And is there any way to actually kind of, is 250 or 350 or whatever the number is acceptable? And if it is, whatever that number, is there a way of actually monitoring and policing that?
Okay, so just to answer that, so the club itself upstairs will not be providing or hosting wedding receptions. 1, 2, the village hall may be, because the village hall is available to hire for, and it is the intention, I believe, that, you know, to accept these. But I think those will be subject to the limits that the village hall has as well on its own occupancy. So I don't envisage, but this is a matter for the village hall trustees. But the village hall, well, technically it could host 200 people. They can't host 200 people seated. So I think, you know, the 100, 80 to 100 would probably be about the limit in terms of the sensible use of the space available.
Of course, quite a large area of the downstairs space is taken up with changing rooms. So the village hall area is actually probably about 1/3 of the total surface area downstairs. So that will be a limiting factor. If members don't have any more questions, I would like to go to Peter Sparham, please, to make his comments, please.
Sorry, sir. Could I ask some questions first, please, before I make my comments?
Certainly.
It's to Mr. Thorpe. It's just following on from the capacity. Obviously, as part of the process, the application has to go to the fire service. Did they have a view in terms of capacity?
I suspect that is a question that would have been covered off in the planning area. Ms. Carroll, could you comment on that, please?
Yes, the fire service are a consultee and would have been consulted about the application, the planning application, and should have fed through that with regards to any capacity issues that they have. I think Mr. Thorpe would probably be able to confirm that was covered and in representations were received.
Okay, thank you. Mr. Thorpe?
Sorry, I'm slightly confused. Is this around the license application, or are we talking about the planning issue? But I mean, I can say that I know that building control have been liaised with and corresponded with the fire service over the routes of escape and the capacity of the building. So that those conversations have taken place and are documented. But that was part of planning, not part of this license application.
Okay, thank you. And that's a fair point. This is a licensing panel. We're not here to get the drains up on the planning application, if you'll excuse the expression. Mr. Sparham?
Yeah, I agree, sir. As we all know, the fire services are responsible authorities in regards to licensed activities, and that's why I actually asked the question. I do have a few questions just for clarification, more of my own mind rather than any particular points I want to make, if that's possible.
Yeah.
First one, if I look at page 26 of the application of the bundle, I just asked Mr. Thorpe what is meant by drinks promotions. What does that mean?
I think you still muted.
Sorry about that. Drinks promotions would thinking nothing more than perhaps we might promote a particular drink in the club at any one particular time, maybe a particular cask ale or something like that. So it's nothing. It was more around providing variety to members and allowing members to comment on possibly whether or not they wanted what type of offering that they wanted. That's what I understood that to mean. So nothing more than that. So if that makes sense.
Well, thank you.
Thank you.
My interpretation of drinks promotions is somewhat different to that. A little bit further down, you've got a duty of care policy for people adversely affected by drink, which is great, fantastic. It is. I'll be corrected by the legal officer, but it is still an offence to be drunk on a licensed premises. How is that going to be monitored?
Well, that will be managed by the general manager or the DPS who's on site. It's it's a small area that we're dealing with here, and that will be supervised. That person would not be working on their own, so there would be other bar staff there. As we pointed out, that we do recognise the obligations to make sure that bar staff are properly trained, and if there's any indication that somebody's is either worse for wear or likely to be worse for wear as a result of alcohol, then steps will be taken. So one would hope that the bar staff would consult with the DPS and action would be taken there. So I think it's just down into the day-to-day or proper management and supervision of what's going on in the bar area.
Thank you. And I think, Mr. Sparham, we must accept that if a license should be granted to this facility, that they will be required to act within the law as it currently stands. And if not, anyone will have the right to complain and lodge an appeal. And of course, as the licensing authority will also be monitoring and ensuring implementation of the law. So I want to reassure you there that there will be, as there always is, a monitoring process in place to ensure that any conditions that we may agree if we are to grant a license would in fact be adhered to. Just to reassure you, is there anything else that you would like to say to the committee in relation to your submission and your concerns, please?
Absolutely. By all means, I don't propose to go through my representations in any great detail, as I'm sure the committee's taken the opportunity to read them. I would just like to reiterate a number of points, if that's possible. I am aware that many parts of the representations, as outlined by Mr. Bryant, have been deleted effectively, and it's restricted to the public nuisance objective. And whilst I acknowledge the unblemished record of the old club, this is not the old club. It's a new, larger, more attractive in some respects venue with a much wider catchment area. The charity has been expanded to the neighbouring parish, which is completely untested and unproven. It also chooses to, as we've discussed earlier on, operate under the less restrictive aspect of the premises licence. So the similarity with the old club ends with the name, and in fairness, that's even been changed. The risk, therefore, in all areas of the licensing objectives should not be underestimated. And I appreciate, Chair, in terms of you saying it will be monitored. I totally appreciate that. It's great. But the immediate effect of any incidents, disturbances, will be on the local neighbourhood, the immediate local neighbourhood. Arising in certain items within the representations, such as parking, barbecues, profanity experienced around the boundaries during training and matches, and most recently some serious breaches of legislation, are excluded from these proceedings, quite rightly so, because they are not licensable activities. However, there is an argument to say that if the club wasn't there and the draw of those licensable activities was non-existent, or there was more consideration and appropriate risk assessments in place, the effect on the local neighbourhood would not exist or be minimal. In terms of the actual representations, hours of operation, we can all have a view. My view, I don't believe, Mr. Bryant, that I am uninformed regarding TENS. However, I will bow to your superior knowledge. However, TENS, I feel, should be used in terms of extensions rather than ad hoc 12 dates for birthdays, as I understand from the application. It's an ad hoc basis, which is difficult to monitor, whereas TENS are clearly able to be monitored. The external areas, I'm grateful that much of this has been cleared up. Licensable activities should be restricted to these areas. I'd also urge that serious consideration be given to the restriction in use of outside space as per my representations. Just over a year, there's been building work ongoing on the site, causing considerable disturbance, not licensable. Machinery aside, music, conversations in various languages and a variety of expletives has travelled to the surrounding neighbourhood and can clearly be heard from adjoining properties. I realise that this is not licensable and could not be used against this application, but it is mentioned purely to demonstrate how noise travels. And this is during the day, sometimes weekends and bank holidays, not to mention, so the effects at night will be that much greater. The applicant has gone some way to mitigate these issues in terms of noise policies, and I'm grateful. This is appreciated, but it tends to tackle the issue retrospectively rather than preemptively. Great idea, fantastic idea. I've seen it happen in many areas where phone numbers are provided, great. But by that time, the disturbance is already done. I'm mindful that games can often go until 2030. That is why I suggested a cut-off point for outside at 2100. I failed to see how 2030 suddenly ends up as 2230. I would urge the committee to consider the restriction of outside space to 2100 and the closure of windows and doors where amplified music or voice is performed. As I reiterate, amplified music and voice. The protection from harm aspect, protection of children from harm, my apologies, from harm section of this application is extensive, and I'm grateful. However, it is somewhat introspective. There's no account of the children and grandchildren that live in and around the location. They deserve the right not to be disturbed late at night. I'm grateful that there's been some attention to the CCTV. I welcome the suggested conditions around it, but would observe that there are multiple entrances to this site. I think I counted 10 or 11 yesterday, which when it's busy, as we say, potentially 200, 300, albeit unlikely on a regular turn, these entrances are going to be left unguarded and will, unlike the old club, which was very self-contained, this is very open. There is a main entrance, but it's very open. I am grateful to the applicant for addressing the issues around glass outside the premises, and would urge that this be a condition. This is an attempt to prevent those using and visiting the club, but also we have to remember this ground is a communal recreation ground. It's not just a cricket club. Hopefully through my representations panel, I've made my position clear. However, if the panel or applicant have any questions, I'll be more than happy to help if I can. Thank you.
Thank you. Could I turn to the legal officer for some advice on the issue of communal grounds, because there has been considerable concern expressed about the balancing between a clubhouse or a public venue, whatever you want to call it, located on council ground. And could you explain how that works, please?
Yes, certainly, Chairman. Mid Sussex is graced with a lot of recreational buildings next to or on its land, which we own quite a few, or in this case, we are adjacent to a separately owned, privately owned building. What will happen is, in respect of the land that we own, the recreational land, or if it was our pavilion, there would be restrictions or license on the license to control the activities, and to, as well as any licensing or any planning obligations, there would be landlord obligations to treat it in a certain way. For example, after a game of cricket, there would be an expectation that there would be a litter pick, or making sure that all the equipment is put away safely and there's nothing dangerous left on the land. Those would be contained with any lease or license that we will have with the club. So it will be a separate agreement, if that makes sense. And sorry, just to say, that would be managed by our outdoor services and our property estates departments as well.
Okay, thank you. So that would address the issue of spectators being sort of around the boundary, watching the cricket and so on. Mr. Thorpe, do you wish to say anything?
Sorry, just on, thank you, Chair. Just on that particular point, just to for the panel's benefit, just to explain what the particulars of this project. We are taking a lease from Mid Sussex District Council on the pavilion site. So the Mid Sussex will be the landlord, and we are subject to conditions within the lease in the way that have been described by the solicitor. Just in terms of recreational space, one reason that this project happened in the first place was because the Sports and Social Club did take on the lease of the recreation ground extension many years, in 2012, and extended it. So we actually took on further property from Norris Farms Partnership to actually make the recreation ground even larger. That allowed the construction of a second cricket pitch. That area is open to the public as well. So not only is the main recreation ground, but also that other area is used by dog walkers and other people, and people come and have picnics on that place. So that did allow, in the sense that the granting of the loss of recreational space in the main recreation ground was compensated by this, this extension. Also, what it does, the scheme provides for ultimately the demolition of the old village hall and the extension of the car park to include another 28 spaces, which was a vital element of this project in order to seek to relieve the impact of visitors to the recreation ground on Deeks Lane. So that's so by way of clarification. I hope that's helpful.
Good, thank you. I'd like to invite Mrs. Emma Sparham to address the committee if she wishes.
Thank you. All I've got to say is really, Mr. Sparham has actually represented all of us who live basically on the boundaries of the old site and the new site. It is a very personal matter. I know this is in a licensing committee, and I know there's certain points which we won't be put forward towards it or taken into consideration. But it's just to say there's lots of families who live around the Sports and Social Club, and over the past year, which has been a very difficult year for everybody, we have experienced public nuisance, specifically from the cricket club. An example on Good Friday, having a barbecue, non-socially distanced, without masks, outside our doorstep. Now, that is one example which is very difficult to talk about because of the situation, and that is in a non-licensing area. Now, with the extended licensing hours, okay, maybe extending is not the right word, so please forgive me. With the new building, it's bigger, it's going to welcome a lot more people, and I do fear that with the ability of people being able to drink for those hours until whatever o'clock at night, it is going to cause more and more nuisance as well as noise to our families and our community. And basically that's all I would like to say.
Okay.
Thank you.
Thank you. And obviously I want to reassure you that we will consider your concerns very carefully, particularly around children and young people who live close by, and we will weigh up the public benefit of the facility in the area as well, in any consideration that we have in granting a license or not. Mrs. Joanna Stedman, would you like to address the panel, please?
Hello, can you hear me?
Yes.
Thank you very much. Just to second what Emma and Peter have both said in regards to the social impacts on what's proposed to the neighbourhood, I'm still not clear on how you're going to police the people that are coming into the club without a membership. I just don't see how you're going to be able to, and I'm even more confused that if somebody's having, I don't know, a wedding downstairs and they come up to the bar, how are you going to know, are they a member, are they invited in? That confuses me as to how you're going to be able to differentiate between Joe Bloggs coming in off the street and using the facility and legitimate members who are meant to be there. The number of people also terrifies me. I have a slightly different recollection of the leasing of the second ground at Anstey. Whilst it's not particularly relevant to this, it primarily facilitated grant money to be opened up to build the building rather than being a charitable exercise to allow the residents and the neighbours to be able to use public ground, which they'd already had use of because it was owned by the council. So that was just an aside on that one. And I'm somewhat perplexed as to you're not comparing like for like. The building that's existing, that's being demolished, is a self-contained, much more smaller, pretty much unglazed building tucked away on the corner of the site, which has been there for some considerable time. And I agree, it has caused minimal problems to the neighbours. What you have got now is a considerably larger property on a public recreation ground, and the blur between the demised property and the wider recreation ground seems to ebb and flow to suit whatever cause we're trying to make it. People feel very intimidated walking around the recreation ground when there's a cricket match going on. So it is essentially used just for cricket at that particular point. Even people living in their houses feeling intimidated walking across the car park to get out, to walk their dogs, to get to the car park. So it does have a wider implication than just what you're outlining at the moment. So that's just a slightly, as you can tell, emotive sort of feeling about the whole thing. But I have supported the development of the scheme. From the outset, I think all of the neighbours were keen to see a new building and going forward and it being a village asset. It's just it seems to be morphing into something that wasn't envisaged, which is maybe naivety, but equally any controls that we can have to stop it morphing into something completely uncontrolled and not what was envisaged by the people that supported it in the first place would be much appreciated.
Yeah, thank you. I want to reassure everybody on this call that if we were to grant a license, we would expect there to be a process of good neighborliness engaged in by everybody, and the club will need to accept the fact that they are significantly larger and different, as you say, to what has been there for many, many years. And there will be impacts on the neighbours, unfortunately. This always happens when things expand and things get bigger. And I notice there's been some concern about the smell of barbecues, and living close to a public area, that's always an issue that gets raised. And the other issues that I'm particularly concerned about are the issues of bad language and excessive drinking over prolonged periods of time. And what we as a panel will have to do is consider all of these things in the context of the legal parameters in which an application like this is granted. And finally, I'm going to ask Mrs. Sedgwick-Smith if she would like to address the panel, please. No, it doesn't appear as if we are. There we are.
Can you hear me?
Yes.
Sorry, new to this. Yeah, I think a lot of it's been covered. I'm very happy with how it's gone and everyone's listening to everyone. And I think possibly what we should consider is having some sort of communication, constant communication that is open between the residents and the association, so that as it develops and concerns are brought to light, that we can actually discuss them as it's going on. Maybe setting up a WhatsApp group or some Facebook group or whatever there is, so that we know who to communicate with. Just say the chairman or the person in charge changes. We need to know the telephone number to contact then and there, not in a week's time. So maybe that's one thing to consider if that's possible, because most of us have either a phone or a computer and are able to discuss our concerns. And I think it might be helpful if that could be taken into account. Apart from everything else, I think most things have been discussed very well.
Good, thank you. And just to reassure you that if we were to grant an application, I would expect the telephone number to remain constant. That's the usual process, and I would expect that going forward. So thank you very much. Mrs. Stedman, did you have a question?
Sorry, yes, I just have one more. I have reiterated it several times, but I am concerned about the fire escape balcony being used for gathering and drinking on. Personally, I just think it's an accident waiting to happen. It is a fire escape in no other circumstances with the, they're sportsmen. They're going to have sports bags lying around all over the place. They're going to be gathering up there and chatting. I completely understand the appeal of wanting to stand there, But I just don't think it's a very sensible idea in terms of public health to have a fire escape being used as a drinking area. That was all I wanted to say. Sorry, I forgot the first time.
Good, thank you. And I should have said at the beginning, if anybody observes the panel members looking away and looking as if they are not engaged, we're actually taking notes. So I just wanted you to be aware of that fact. And now, Mr. Thorpe, I'd like you just to address the panel and make any concluding points that you might like to make, please. You're on mute still, Mr. Thorpe.
I'm sorry.
No problem.
Sorry. I don't want to make any further points. Maybe just to respond to just a couple of points that have been made, if that's okay, because I do think that we've had the opportunity to air the application fully and take the comments. So I thank you for that. The balcony area is a fire escape, but it's not solely a fire escape. It is actually 3 meters wide, but there is an area that we will need to maintain as a clear area in order to provide a primary means of escape from the snooker room and a secondary means of escape from the club room, so that we are fully aware of the issues there, and that there can be no furniture or baggage or anything in that corridor, because that has to be done. Just on activity, there is already a very full programme of cricket activity in the summer on the site. There's little scope to do much more. We hope maybe with improved parking facilities we can, and the way in which we manage the site, to actually reduce the volume of activity on particular days. So like on a Friday evening for practice and things like that, to see if we could actually do something that would distribute it more evenly. But just to say that the cricket club is primarily a club which has, girls and junior cricket. We run age group cricket from up from age 6 right the way through to 16. We have 4 senior sides and we have 3 women's sides, and we're bringing disability cricket to the site this summer. We are very acutely aware that we are a family club. We have responsibility to those families. We equally have responsibilities to the residents. We know that. And so, anything where we do get things wrong from time to time, if we do get things wrong, we will deal with it. And because we absolutely understand our obligations. And, if it's bad language from players or anything else, that is simply not acceptable. So we will deal with those things. And I'm saddened to hear those things, but I don't doubt that they exist. We will not be doing barbecues in the area ever again up on that area. We made a serious mistake a few days ago where we had a working party on the ground where and somebody decided it was a good idea to provide some kind of refreshment at the end of the working party, with a number of different groups working in small pockets around the ground, and something that had been carefully planned in order to make sure that we were socially distanced and people working in family groups. We got it wrong. We have suspended all activity on the site for the next few days until we go back and review all the COVID guidance and make sure that when we do start cricket training again on the recreation ground, that every manager and all parents and all participants understand their responsibilities. So we will deal with that. And the idea of a WhatsApp group, I really would welcome that. I think rather than just simply having a telephone number, but establishing a dialogue would really be very helpful in moving this forward, and clearly dealing with any issues, but equally seeking to reassure neighbours that we are seeking to manage this responsibly. And we're not looking to grow our sporting activity, particularly because there's a lot of activity already on the site. So there are small windows where we think we can do it, but I don't see that there will be significant growth. The only area that we are seeking to do that is with the residents and offering this discounted residents membership, because there are no social meeting spaces in the village. That's all. So, Chairman, that's as much as I've got to say. Thank you.
Well, I started the session by talking muted, and I'm going to end the session by talking it muted, and I'm sorry about that. I would first of all like to thank everybody for the manner in which they have presented their concerns and their cases. I would like to thank Mr. Bryant for his very comprehensive report at the start of the meeting. And if I could go to Frank Carroll now to please just outline the process going forward and how this will be concluded. Thank you.
Lovely, thank you. The members and myself will retire to a private holding room where the matter will be discussed and a decision will be reached today. If a decision can't be reached today, it will be communicated to you. We will let you know. The legislation requires us to reply with a decision and reasons within 5 working days in any event. So a full decision will be set out to you in a letter. And in that letter, it will contain the details of how to appeal if you wish to appeal and what the conditions are. It will be a full letter setting out what has transpired today and what the decision is of the committee. Lovely, thank you, Chairman.
Franca, I just want to confirm that that letter goes to all parties involved.
Yes, everyone who has made representations today, I think everybody has taken part, will receive the decision letter will go to the applicant and a copy will go to all the people who've made representations. Just to add, the period in which to appeal, if you are going to appeal against the decision, is 21 days from the receipt of the letter. And that's to Brighton Magistrates Court. But I'll set everything out in the letter.
Okay, good. Thank you very much. And again, thank you to everybody for your participation. And I would ask the Democratic Services staff to remove us to a private room, please. And to all those people who've joined us, thank you very much.